Welcome along to TweetStreet Scotland Occupied, home of the satirical saltire. I'm Cinnamon Bridges, aka Peter. I'll be the host for this evening for this event titled Unjust Scotland. It's organised by the Alba Party, the Equalities convener and panel member for this evening, Eva Comrie. As host, I wish to ensure an open and honest discussion, as the aim is to achieve a dialogue about where our systems are failing, as well as where they may be working. The panel consists of Advocate John Hawley, Andy Bryson, Scott Forbes, Jimmy Ross, Gordon Miller and Eva Comrie. Eva is who we'll start with this evening. So Eva Comrie, over to you, please. Please unmute yourself.
Thanks very much, Peter, and thanks so much to the panel and to the audience. I hope that we're going to have a lively, honest and open debate tonight. And for all that this is organised by the Alba Party, it's not intended to be party political. It's about, as Peter said in his introduction, looking at where Scotland's getting things right and where we're getting things wrong. From my perspective, I would like to talk particularly about issues that affect Scotland's children and the way that the justice system deals with children in relation to children's panels and the care system, and also in the civil or family courts. I think that it's perfectly obvious to most people here tonight that there have been very serious issues over the course of the past couple of years within the Scottish court system that have been flagged up by COVID, but not necessarily resulting only from the impact of the pandemic. What I've seen unfold, unfortunately, is a very obvious divide between the children who are subject to the care system and those children whose arrangements for their care might be what we would call family arrangements. Very early on, after lockdown, it became evident to me that there was a two-tier system of justice for children here. There were two different sets of guidance went out, one from the Scottish Government and one from Scottish courts. The latter was from the Court of Session judges, and it was a practice note requiring that parents or families who shared the care of their children should continue to do so even during lockdown, and they were not necessarily to be bound by any of the arrangements for lockdown, whereby we were supposed to be isolating in little family bubbles. A very different position applied in relation to children who were subject to supervision or care orders. If they were children who were living away from their family at the time of lockdown, then that position remained, and whether or not they got to see their family, meet their family, have FaceTime or even email communications with family depended very much on whether they had a social worker who was willing and able to conduct a risk assessment. That didn't happen for many children. So for some families, they went quite literally from March until August 2020 with family contact being restricted to only the occasional email and, if they were lucky, a FaceTime call. I now have two different sets of correspondence about these two different arrangements for children, showing very clearly an obvious divide between both those who were in care and those who were not. To add insult to injury, it was abundantly clear during the whole process of the first lockdown in 2020 that if any preparation had been done for that, it had been very piecemeal and, in fact, pretty shambolic, to put it mildly. So children who were subject to the children's panel and were on what we call a supervision order should have had their cases reviewed periodically. Very many of those reviews took place without the parents knowing, without the parents being able to participate, without the parents having access to background reports on which panel members based their decisions. And many of these panels, especially between March and July, were only conducted by two children's panel members having a swift telephone call with the children's panel reporter. And if the parent was lucky, the parent might have had access to somebody like me or Andy, who could have sent in a letter on their behalf explaining what they wanted and why. Instead of having a face-to-face panel where parents, social workers, child and panel members could have an open discussion, instead there would be a phone call where an excerpt from a lawyer's letter would be read out by the children's panel reporter to the panel members. They would intimate their decision, and that decision might take several weeks to be conveyed by the reporter to the lawyer and then by the lawyer to the parent. That position applied nationally. I don't know how many children and families were so affected, but I would imagine that the damage on a human scale would be immense. When that process became redundant, it was replaced by a slightly different position whereby children's panels could take place by video link known as VScene. But if you were a parent and if you were skint, you could only participate in those VScene hearings if you had a mobile device enabling you so to do, and you had access to broadband or Wi-Fi. It goes without saying that very many parents would not be in a position to afford that. And I would imagine that, again, across the country, there must have been hundreds of children who were affected and parents who were affected by poverty that resulted in them not being able to actively participate in the decision-making process for their children. That process was very briefly in about September, October 2020, replaced with face-to-face children's panels. But again, they were pretty shambolic, not least because there was dubiety about the arrangements that there should be in relation to social distancing and whether or not face coverings or masks were to be used. And then in the end of 2020, we went back to virtual hearings, which have mainly been conducted by Zoom. But those children's panel hearings have something very unfortunate in common with civil proceedings or family proceedings in the sheriff court, where sheriffs are making decisions usually based on virtual hearings where sometimes parents can participate, but in my experience, more often than not, connectivity and access has been incredibly poor, and that's compounded by difficulties whereby individual people might not necessarily get a chance to speak like they would if you were in a face-to-face hearing in a sheriff court. But I would say the culmination of both sets of processes, whether it's a children's panel video hearing or a sheriff's hearing by video, the result's usually the same. Everybody leaves a hearing feeling disappointed and dejected because they either didn't get to have their say, or they couldn't hear what other people were saying, or decisions were based on very partial, incomplete, sometimes inaccurate information. And all of that, I think, is just nothing short of a disgrace to the Scottish legal system. So from my perspective, I think that when we consider poverty, we should include in it not just financial poverty, but also digital poverty, and we should make it very plain to those who govern us and those who make decisions about how to run our systems in future, that we expect that everybody will get a fair crack of the whip, and that we won't be left with this kind of situations that I've seen over the course of the past 2 years, where families have at times been decimated as a result of the behaviour of those who were supposed to be looking after them, a lack of accurate information and a lack of will to address these issues. I would cite particularly a number of parents I knew who didn't see their children for months. I asked when various local family centres would be reopening and got nothing but the runaround from local authorities and from elected politicians, to the extent where when some people were able to see their children again, what they got was an hour's walk in the country, somewhere in Clackmannanshire, once a week. And that was for families who had been used to seeing their children several times a week before lockdown. So as I indicated earlier, the human cost of the misery that lack of planning, lack of understanding, and quite frankly, lack of care caused is something that I hope will come back to haunt those who were responsible for those decisions. That's all I would want to say at this stage, because I'm quite sure that others will have a lot to say about other shortcomings in different aspects of our justice system these days. Thank you.
Thank you very much, Eva. I now invite Advocate John Hawley to speak. John, if you unmute, and feel free to start when you're ready.
Okay, hello, my name's John Halley. I'm an advocate, as I've been introduced. Since for present purposes, I'm here to talk about developmentally appropriate questioning of children. Now, for anybody who works within the court system or social work services or police, you will know this as being something that is associated with joint investigative interviewing. That's essentially what it's become strongly associated with in Scotland. I'm actually going to be suggesting, I hope if I manage to pack all of this into 10 minutes, that in fact it's something that should be more broadly applied than that. Developmentally appropriate questioning of children and young people is necessitated by a worldwide consensus of essentially psychological evidence that demonstrates a fundamental truth, a fundamental principle. The fundamental principle is this: children and young people are developmentally disadvantaged in forensic discussions or communications with people in authority. Now, the fundamental principle applies to children and young people, and there's lots of science, lots of robust research that absolutely demonstrates this conclusively. It doesn't just apply to children and young people if they are victims and witnesses. It applies to children and young people if they're in conflict with the law. If in Scotland now, if they are 12 years or over, if they are suspects or accused persons in relation to criminal allegations, it applies to all children because they are children. I've termed this talk in different contexts linguistic human rights, and really the reason that it's been pitched in that way in other contexts is because it's founded in some of the fundamental articles of the UN Convention on the Rights of the Child. And of course, adoption and entrenchment, embedding of the UN Convention on the Rights of the Child is something that we're very keen on, rightly, in Scotland. The essential articles that I am founding on here are, firstly, Article 12, which is essentially the right for a child to be able to express a view in matters affecting them. Obviously, in order to be able to express a view, a child's view, if elicited, for example, by a sheriff in chambers, the child's view has to be something that the child is able to express in their own words, and as a result of questions that they have absolutely understood. This isn't just about using child-friendly language. If it was as simple as that, there wouldn't be a problem and there wouldn't be the huge evidential research base that I've been talking about. The problem is we as adults engaging with children in these forensic contexts have to stop doing what we normally do. We have to stop teaching children and young people. We have to stop suggesting things implicitly or explicitly to them. And that's what the science helps us do. It helps us discipline ourselves and make sure that we are approaching children on a disciplined basis that affords them the opportunity to express themselves or to understand matters such as the right not to express themselves in their own words. So the fundamental aspects of the UN Convention on the Rights of the Child that I'm founding are, as I say, Article 12, which relates to criminal and civil proceedings, the right for a child to be heard. Article 37 and Article 40 relate specifically to children in conflict with the law. They're really important, and probably the right that most people will think of within the context of those articles is the right to silence, as it's become known. If you're being questioned by police, then you have a right not to incriminate yourself. Children have this right by virtue of the UN Convention on the Rights of the Child, but it means little or nothing if they are being questioned by people who don't understand what the science says. Now, in Scotland, we have consciously, politically, opted for protecting victims and witnesses correctly. Of course, we have to protect children who are victims and witnesses and furnish them with trained police officers and social workers who can apply the science in order to afford them the sort of special measures that they need to be able to give their evidence. But we have not... can you still see me?
Yeah, I can still see you. I just think somebody's mute had come off there. John, sorry about that.
They have not applied the science in relation to children in conflict with the law. They have consciously decided not to do this, and it's not fair on a very basic level. In fact, arguably, it is prohibited by Article 2 of the UN Convention on the Rights of the Child, which prohibits discrimination between children. You can't treat victims one way, victims and witnesses one way, and treat children who are in conflict with the law or accused and suspects. It's useful to try and unpack that last bit a wee bit, because children who are under 12, i.e. not capable of committing a crime under our new regime, having raised the age of criminal responsibility, those children can still be interviewed by police in relation to matters relative to their welfare. Under the new legislation, a sheriff can grant a child interview order, and that child will be interviewed by police officers and perhaps by a social worker as well, but they will not necessarily be trained in the joint investigative interview type questioning method and questioning structure. Now, it's really important that people understand this, because it's a fundamental error, it's a fundamental flaw in my view. I could go on all day about the science that backs this up. As I say, there is absolute consensus about it, there's no doubt. In Scotland here, we have robust evidence as well, gathered by the same scientists and analysed by the same scientists from the Scottish courts. They have had access to transcripts of all criminal trials involving child witnesses between 2009 and 2014. They have analysed all the questions asked by prosecutors, defence counsel, judges, and surprise, surprise, they have found the questioning methods and the questioning structures wanting. It's not good enough. It doesn't scrub up to what world-class standards demand in terms of the UN Convention on the Rights of the Child. So there's a problem. We can address it. We're addressing it for one set of children. We're not addressing it for, on another view, another set of children who really, really need it. There's robust research that says even adolescents may well not have the capacity to properly understand that fundamental right not to incriminate yourself. Don't have the capacity. It's not just me that's saying this, it's the behavioural scientists. So I'm emphasising that point because it's really, really important. We need a fundamentally different approach to questioning all children, and it's the approach that's taught to police officers and social workers who are involved in the joint investigative interview regime under the new Scottish child interview model. I don't know if I said at the outset, but I have been teaching that, and I have written a part of that course, been teaching it since 2017 to cops and social workers, who I have to say are fantastic and have really responded well. I think that's probably my 10 minutes up. I'm open to questions afterwards.
Thank you very much. We'll now move on to Andy Bryson. Andy, it's over to you. Unmute yourself, please, and whenever you're ready.
Thanks very much. I was about to say to John there, you can probably have some of my minutes, because I probably don't have as much to say as the rest of you. Just to introduce myself, my name's Andy Bryson. I'm a solicitor in Falkirk, and the practice deals with a mixture of criminal and civil matters. Almost all of it is legal aid. And Eva very kindly asked me to come on and speak about some of my experiences in the virtual court system that we're now stuck with. Well, maybe not stuck with, but certainly using at the moment. Now, it's perhaps worth setting out how things were before the pandemic. Now, before the pandemic, dealing with custody cases, people appearing from custody charged with crimes, they would be arrested the night before or the weekend before. They would appear in court the following morning. They would have their papers served upon them, and they would have the opportunity to see and read what they were charged with, and then speak to their solicitor about the charges and what they wanted to do about it. And that was face to face, down in the cells. And the solicitor would then be able to go up to court, speak to the prosecutor, agree pleas, speak about bail, go back down and see the client, and discuss all these things with the client. Now, the strange thing is when COVID hit, there was no change to the way custodies were done. There was less of them. The police were given an instruction, don't lift as many people. And for a number of months, the custodies were way down, and they were putting through as few as possible. However, they were still putting them through in the old way. They then brought in, and I'm trying to think when this would have been, but certainly at some point last year, so it was well into the pandemic, they brought in virtual custodies. Now, it obviously wasn't a response to a health concern, because we'd done it the old-fashioned way through the worst of the pandemic. It was possibly a way of trying to cheapen the way of administering people coming from police custody. The idea was people wouldn't come to court, people would stay in the police cells, people would stay in central police locations, not every police station, just some, and they would connect to the court by video link, and they would speak to their lawyer by video link before their appearance. Now, there are a number of problems with that. Firstly, the way it goes is the person sitting in the police station won't be served with their papers, so they won't ever get anything from the police or the prosecutor. What they will get is, if they're lucky, we get an email and we are given the papers, and the papers are the charge and a summary of the evidence, and that can be quite a bundle of papers. So we then have to arrange on a video platform, not unlike this, to call into the police station to try and speak to this client. Now, unfortunately, no investment was put into the video booths, so they were very limited in number, and you had to try and get a slot, and if you missed your slot, that's it, you were buggered. You didn't get to speak to your client. You had to phone them and speak to them and take their instructions over the phone. Now, they then have a time slot for a virtual court where the client will appear on a screen in court. You're in your office, the sheriff is in his chambers, the fiscal is in their office. Basically, it's Zoom, it's a secure Zoom, and the client will then be asked to tender their plea. So you'll have people who will never have seen their lawyer face to face because they've had to rely on a phone call. You will have people who have only the sketchiest knowledge of what they're charged with and what the evidence is, then being told by a face on a screen that they're being sent to prison, or they're being remanded in custody for trial or for deferred sentence. And it just wasn't good enough. Now, thankfully, that was a pilot which we could see the shortcomings of, and we lobbied, and the pilot is not being extended. So that we're going back to the old way of doing it. But it was frankly a disgrace, an absolute disgrace. And it was so open to abuse. One of my clients, very well known man in Falkirk, long history of mental health problems. And I couldn't get the video conference beforehand. So I had to rely on a phone call. So I phoned up and chatted to him. And we were waiting for the case to start. And he said, Andy, I'm absolutely freezing. And I said, Robin, why are you freezing? And he said, well, I'm sitting in this cell naked. And it turns out he had been arrested the night before. There had been a rammy with the police. They'd stripped him naked and thrown him in a cell. And probably 14 hours later, he was still completely naked in a cell, freezing cold. Now, that wouldn't have happened if he had been processed, brought to court. He would have been dressed, he would have been having his dignity protected. And as it was, he was languishing in a police cell, freezing cold and completely naked. And it's just not acceptable. Thankfully, that is being ruled out. But there are ongoing difficulties with the civil court. Now, at the start of the pandemic, civil cases that call in court are primarily family cases. So it's people who are engaged in disputes about contact or residence of their children. That must be 90% of civil cases in the Sheriff Court. And these are always called in court. And one of the most important callings of a contact case is, I think, called a child welfare hearing. They are informal hearings with the sheriff, the parties, and the party solicitors, and they are designed to try and resolve contact issues to children. they're important meetings. They can be very, very difficult meetings, but they're always done face-to-face, and actually they're good, they work. Pandemic hits, they just stop them completely. For about 4 months, there were no child welfare hearings, none at all. So people had their cases suspended, they weren't able to raise cases, they weren't able to bring disputes or problems to the court. Nothing happened for 4 months. They then started the child welfare hearings up again, and they did them by phone. They did them by phone between the sheriff and the 2 solicitors involved. The parents were excluded from that process. So people were having to depend on the solicitor to argue their case, not hear it, not be involved, and then they would find out at some stage afterwards how that had gone. That was very unsatisfactory. They then brought in a system called WebEx, which again is a secure Zoom. And what happens here is that everyone is sent a sign-in, they join a meeting, and there is then a discussion. However, it's very much dependent on how people can access that, whether they have the ability to do that, either through their own ability to access technology, or indeed the equipment that's available to them. And this was brought into very stark focus for me recently. I was at a course last week, an online course about financial provision in divorce, which was all lawyers who are much younger than me who were on it. And their position, that there was a roundtable talk about virtual justice, and their position was it was a good thing. They could do it from their office. Their clients, who were mostly wealthy, could do it from their office or their home. Their expert witnesses, their actuaries, could do it from their office. One guy was on banging on about how he had a 3-screen setup where he could have a witness on one screen, productions on another screen, you know. And I just eventually chipped up and said, well, what about the wee guy down in Bainsford who's trying to access this with a 6-year-old cracked Samsung? And there was silence, and no one can really answer that point, or appears willing to answer that point, that poor people are completely excluded from these hearings because they don't have the technology to join in. Even when they are involved, the technology that they have is so lacking in function. Even if they can see what's going on, most of the time they're not hearing what's going on. So 9 times out of 10, I will do one of these hearings. The client will be on the phone within minutes to say, what happened there? I couldn't hear, I couldn't understand what happened. You know, courts are bewildering environments for people who are not used to being there. They are quite intimidating. They are strange, bewildering environments. If you're sitting in the court, if you're viewing this from the end of a screen, you are completely removed from the reality of what's happening, and you have no chance of following what's going on if you're at all unsure what's taking place. So the very process is excluding people from their own cases. And there is no apparent willingness on behalf of the government to change that at the moment. The feedback they're getting from many, many users of this system is that it's working fine, and they're ignoring the people like me who are acting for predominantly poor people to say this just isn't working. So that's where we are with virtual justice. It's frankly a disgrace.
Thank you, Andy. We'll now move over to Scott Forbes for his comments. Scott, please just unmute yourself, and whenever you're ready.
Hello. Listen, this is my first time ever on Zoom, so you will excuse if there's any hiccups. I do apologise. Listen, my background, I was sent in the listee school, approved school, to the children's panel, so at the age of 14. I went through all courts, High Court, Sheriff Court. I was sent to prison at the age of 24, served 4 years. And then I was able to persuade the Law Society I was a fit and proper person to practice law after 10 years at university. And for the last 15 years, I've been studying cold cases, possible miscarriages of justices, and people who have been wrongly convicted. I was very interested to hear John Halley earlier speaking about children's victims, children witnesses and children victims, children accused. For the last 18 years, I've been involved in a case with a boy called Luke Mitchell, a terrible case. Allegedly, he killed his girlfriend, and I use the word allegedly very strongly. He was wrongfully convicted. Now, everyone in the justice system, and I mean everyone, the Scottish Criminal Case Review Commission, lawyers, judges, QCs, advocates, of criminal pathologists, scientists, they all know this boy didn't do the crime. Now that 10, 12 years goes by, and still everyone knows that this person didn't commit the crime. But to go back to the Scottish justice system and ask to get access back to the like forensics so we can reinvestigate is impossible, because someone found someone guilty, a jury found someone guilty. That person is guilty irrespective of what evidence you produced after. Now, there is a law, new fresh evidence. There has to be evidence that was not available at the time of the trial. So if you have a lawyer who's turned a blind eye or been too lazy to read something that's very compelling that was available to the defence, you cannot therefore bring it forward years later. The Scottish justice system is archaic. That's only my opinion. If you go into the appeal court, you try and speak to a 3-court bench and tell them this man's innocent, but everyone knows he's innocent. Or sorry, everyone suspects he's innocent and there's a miscarriage of justice. It still takes you 10, 12 years to get access to evidence that could prove that fact. Now, that's only one case. I'll give you another case. A boy called Sean Toll, many years ago, was convicted of a murder. 10 years later, it took us 5 years to access the knife. They say that the murder weapon could not have been the murder weapon because it was too thick. I'm a carpenter to trade before I went to university. When I took measurements in millimetres, I knew the pathologist was wrong. That's a very big step for a carpenter to tell a pathologist that they're wrong. Anyway, I took that step, and then Professor Basutil admitted he's wrong, and a man called Professor Pounder acknowledged what I'd said was correct. And the man spent 13 years in jail for a crime that he never committed. Now, 13 years, there should be an easier access for people to access evidence of cases that are allegedly closed. And I go back to the case Luke Mitchell. Luke Mitchell was a child of 14 years of age. He was interrogated, and I use the word interrogated purposely. The High Court and the Appeal Court accepted the word interrogated. They were dragged for their cars at 8 in the morning like terrorists over the street, handcuffs, taken away and interrogated a boy of 14 for 12 and 13 hours. And it was accepted that that was permissible. His brother was taken for a car at 8 in the morning, and the High Court, the Appeal Court ruled if he had been a witness, a suspect rather than a witness, then his evidence wouldn't have been admissible in court. So therefore, they dropped the accusations against him, made him a witness, and therefore his witness statement was allowed in court. Children in this country don't get proper legal support. John Halley's right. Children in police stations are like terrorists. And I'm only using one case here as an example. A young boy, 14, was taken into a police station, strip search, no appropriate adult, no social worker. They put a police officer in the home, but she was spying rather than trying to help. And they terrorised the boy for 12 hours, interrogated him for 12 hours, and it was admissible in court. Children in this country are not protected. I was very interested to hear Andy, because I've been in Andy's situation. They cells many times as a young man. And unless you've got a very decent solicitor who's willing to come in and look after you in these situations, you're left to rot. You're left to rot. Listen, this whole debate I'm hearing is digital, and I'm generally this is foreign to me. I'll go back. The Scottish judicial system has to be overhauled throughout. the sheriff court, most lawyers, and I'm sure Andy would agree on this, don't take clients to trial. They take deals because they get the same legal aid payment. So it's easier for you to say guilty or not guilty and give a plea in mitigation rather than do a 2-day trial for the same fee. The high court trials, oh, listen, some of the investigations that go on in defence of a client is really a joke. Now, I don't mean legal aid has to be stepped up, because people abuse legal aid. I've trained solicitor, I've seen it. Lawyers maximise their legal aid. They have to. It's like any profession. If you've got a certain guideline, you maximise that to make as much money as you can. That doesn't help the client. That only helps the lawyer. That sheriff court, high court, both are the same. Both are the same. The children's panel, Eve, I would love to work with. I would love to work with. I went to the children's panel age at 13. Terrified. My mum and dad had broke up. I got put in List D school for not going to school. When I went to List D school, I didn't have to go to school. I could go and work on a farm. So they traumatised me, taking me away from my home. They put me away somewhere for not going to school, and then I didn't have to go to school. The children's panel, only in my opinion, is out with the communities that the children that they see over. There should be more community-based panel. Right? And I understand people say they advertise now and they bring in people, but most people, generally speaking, in the children's panel are middle class. We have generally no idea the kids that they're looking at, and that has to be addressed. The sheriff court, I'm sure Andy's going to agree with us. The sheriff court is especially Edinburgh, Glasgow, is a circus. People who are uneducated and ill-informed, with poor backgrounds, just get told, listen, just plead. And they plead guilty, crimes probably never committed, and they plead to lesser charges. The whole criminal justice system in Scotland has to be reviewed. And on that note, listen, I have to leave. I'm getting quite shy talking to a camera. But listen, all right. Listen, good night.
Thanks very much, Scott. And first time taking part. You've done well. Thanks very much, Scott.
No, thank you.
Next speaker, if we can have Jimmy Ross, please.
Hi, can you hear me?
Yeah, I can hear you now. On you go, mate.
Well, my name is Jimmy Ross. I was a police officer for 30 years, including quite a long time as a child protection officer. I also did my stint in the CID, community policing, and I beat Bobby, which I enjoyed. Fortunately, I managed to avoid the traffic department. I was going to talk about the decriminalisation, regulation and legislation of drugs, but I noticed another attack on the justice system by one of the anonymous complainers through a Scots government funded organisation, which is often criticised by women's groups with regards to their administration and ethics. That had me changing tack. I'm not going to dwell on the hate crime bill, but I fail to understand why it was ever necessary. To the best of my understanding, it was covered by current legislation. The major things that I notice is that it managed to miss out the scourge of sectarianism in Scotland, and though it did make a special crime of hate against sexual orientation, it didn't really mention biological sex at all. I think that's all I need to say about that. But my main point here is jury trials and steps that are being made to dispense with jury trials for some offences. It's something I just cannot agree with at all. I think there's no justification for it. A perfect example is jigsaw identification, which is a crime that is unknown elsewhere in the world and which no one quite understands. And it's only a crime committed by certain people because others who have done the very same thing were given immunity from prosecution. I'm sure if that was in front of a jury, the person involved in that would never have been convicted. Now, the other thing that bothered me greatly was, I'm talking about the same trial here, the Alex Salmon trial, where details of the, and it must have been complete details of the alleged crime, including most of the charges as far as I can understand, were released to a newspaper. Now, how can that not be contempt of court? You know, I just can't understand that. You know, attempt to pervert the course of justice, defeat the ends of justice. You know, it's bound to influence people's idea of guilt or innocence when a man is convicted in a newspaper, for want of a better description. Now, surely when that information was released to a newspaper, there should have been a criminal investigation immediately. And the source of the leak determined and prosecuted. You know, if you take what happened to Mark Hurst, he had every form of technical assistance seized by the police, tablets, laptops, phones, computers, which they examined in great detail. Has that ever happened to whoever leaked the details to a national newspaper? You know, we then had information that the police inquiry, which, to be quite honest, in my experience, was the biggest fishing expedition in the history of the police in Scotland. We have information provided to the court in WhatsApp messages and text that there were attempts made to influence the conduct of the inquiry. Nothing was done about it. You know, if these things are allowed to go on in Scotland, there is no way that we could ever consider removing jury trials for any crime. There is a problem with the rape with conviction for rape. That's understandable. And I don't know if removing a jury is going to make any difference, because a couple of speakers have mentioned here, I have to concur. You have to have expert investigation, competent investigation, and you must have a competent prosecution. Then I would assume, or I would hope anyway, that the conviction rate would increase. Because at the moment, that's not happening. And I know my talk, I was going to rattle on about drugs for some time, for a lot longer than this. But I think it's important, or very important, that we really resist any attempts to dispense with jury trials in Scotland. So I'm a bit short here, but that's all I have to say, and thank you for listening.
Thank you very much, Jimmy. Over to our last panel member to speak now, and returning panel member, we have Gordon Miller. Gordon, over to you.
Right, hi. I'm an accountant and I'm currently based in London. And so I'm coming at things from a slightly different point of view. I haven't experienced any of the fairly horrible things that we've heard so far. But I do think one common theme that's running through this is that things seem to be done for the benefit of the government or whoever's in charge, rather than for the benefit of citizens or of people. Now, I see this in my day job. I'm a tax specialist. I started life as a tax inspector before I moved over to become an accountant. And the digital divide is a bit of a nuisance, but I'm not sure if we are not trying to solve the wrong problem. There is obviously a problem with digital access, and again, it's tied in with people being poor. And COVID has shown just what a problem this can be for some people. But like I say, are we actually trying to solve the right problem? Because there have been attempts at addressing this. The Labour Party put it in their manifesto in 2019. And there was a debate in Westminster in October last year, I think. And if you look at what was said, the Labour Party wanted public ownership, and they wanted of the internet, essentially, with digital access funded by taxation. The Westminster debate was all about having special rates and making it cheap and possible for people with a lack of resources to get on to online services. But these are both kind of essentially money-driven solutions. And they assume the problem is lack of access to the internet, rather than stopping and saying, well, why is this a problem in the first place? Nobody seems to look at how and why we got here. And I think this ignores what's possibly the main problem, which is that since the 80s, we've been told over and over again that the public service system is inefficient, it needs to be streamlined, people need to take responsibility for themselves. And we've kind of accepted that the cost of government is a kind of undesirable cost that we want to keep down. What we should be asking is, what is the government for? Who's it supposed to benefit? Is less spending on the public sector actually a benefit to everybody? Because that is the real issue. I think the digital divide's a bit of a red herring. It's a political choice. It's not just a problem of lack of digital access, it's why force people to go digital in the first place. So my view is that all governments since the 80s have been focused on cutting costs, cutting the number of public servants, civil service, and so on. Now, I'm going to talk mostly about the tax office, inland revenue, because that's my particular area, but I think that it would apply to almost any other local government service. Starting with self-assessment, that's been going for 25 years now. And there was a very self-congratulatory article in an accounting magazine that said that before self-assessment, the responsibility for calculating someone's tax liability lay with the tax office, and that the tax office often got it wrong and they were late. And now that self-assessment had been introduced, everything was fine. That's complete rubbish. It was rubbish then and it's rubbish now. What was then the Inland Revenue were actually very highly trained. They rarely made mistakes. I was a graduate entry, and it still took me 3 years of day release training and 2 years of consolidation before I was considered fit to take over running the smallest tax office. And they worked on very strict time limits. Over 14-day post was a big no-no when I was a management inspector. Now you're lucky to get a reply within months. And in any case, it's still the tax office that calculates the tax. You don't do it yourself. But the real impact of self-assessment has been to dramatically cut tax staff It's closed almost all public access to tax offices. It's cut training costs. It's replaced trained staff who knew what they were talking about with people sitting on phone lines with a script. And it's allowed them, incidentally, to sell all their buildings to private developers. And the overall result of this is that the service to the public is much poorer. You can't have face-to-face meetings with someone who understands the problem in the system. Telephone waiting times are absurd. And it's difficult to correct errors because you can't do that online. You've got to correct errors by letter quite often, and that can take forever. And another reason I think that we're maybe looking at this the wrong way is it's not just the poor who are affected by things being shoved online. There are lots of people. My brother is a good example. He's a writer, so he's not stupid, but he is just completely foreign phobic. He couldn't do his tax return to save his life. I have to step in and do it for him. The forums, the online forums, are not user friendly. They're far too long. They try to cover far too much. And I have clients who used to do their own tax returns, but they just won't anymore. It's too stressful. Now, I don't mind being paid to do it, but they really shouldn't have to. And that brings me on to another thing, which is the design of the online environment and the design of online forums. It's another thing that shows you the priorities of the government. Because I suppose you're probably familiar with Caroline Criado Perez and her book on how the world is kind of designed around men, so that safety features on cars are designed for men and not for women. We have a slightly similar issue online. The online forums are designed by IT specialists for the benefit of other IT specialists, and they're for the benefit of the person issuing the form, not the person who's going to have to fill in and use the form. You get, for example, you get starred boxes. Everybody knows that if there's a star in the box, it's compulsory. You've got to fill it in, or you can't move on to the next page. On a paper form, you can miss out lots of things. The form will you can still send it in, the form will still get processed. There's just one size fits all. There's too many unused boxes on the standard tax return. You can go for pages without having to fill anything in. And people who are not tax specialists get nervous about this. They think they're doing something wrong. Why am I not filling anything in? I must have got it wrong. They ask for far too much detail that they don't need. Paper forms, I mean, I'm not suggesting everybody goes back to paper forms, but if people have the option, you can avoid these problems. And when I talk about them not being designed properly, I mean, this is a story against myself, but I've been working in tax for years, ever since I left university. I'm a professional, I know what I'm doing. And there's a bit on the tax form that says if somebody's an employee, you've got to put in their employer's PAYE reference, and that's a starred box. Now, somebody like me, professional, comes along, I look at that, I see starred box, I know what that means. Pay-as-you-earn reference, I know what that means, and I don't have it. And so there's absolutely no reason for me to click on the little question mark beside the box, except it turned out there was. I discovered completely by accident that if you clicked on that, and it told you all the obvious things I already knew, but right at the bottom, it said, if you don't know the PAYE reference, you can write none in the box. Now, if you can write none, that should have been on the face of the form. That should have been right there so that everybody knew it, and you didn't have to look for it. And like I say, it wasn't designed either for somebody who didn't know very much about tax, and it wasn't designed for a professional like me, because it was completely misleading. And so again, we should be asking, why are the forums designed like this? Who are they supposed to benefit? And are they really more useful, more effective at gathering and processing information? And again, the problems with online systems tend to get skipped over, as if the actual problems of doing things online are ignored, and everybody focuses on this access question, which I don't think is right. And the private sector benefit a lot from this. I have to buy in commercial forms to file corporation tax returns and VAT returns online. I used to be able to do these using the tax office system, but they stopped that for no reason. And now I've got to buy in this stuff. They sold all their properties. When they are actually considering this digital divide and doing something about it, again, it's all for the benefit of the private sector. The government has plans to have 85% of properties with good broadband access by 2025 or something. 80% of that is going to be funded by the private sector and only 5% by the government. And then they outsource the tax office debt collection, which should be a professional service. They outsource it to a bunch of cowboys, debt collectors, who write the most appalling, threatening letters to people, making threats that they simply shouldn't, they can't enforce anyway. This sort of thing shouldn't be happening, but the government is quite happy doing it. So instead of looking at why people can't access digital, I think we should be asking, how can government at all levels make things better for citizens? Why is public service a cost that has to be kept down? Why is there no proper public service ethos promoted by either the Scottish or the Westminster governments? Has anybody ever done any proper cost-benefit analysis of having a small tax office in every reasonable town where you can actually go and meet somebody who knows what they're talking about? Because I'm pretty sure they haven't. So in conclusion, I think I'm not a Luddite. You can't uninvent the internet. But everything that they do is done for the benefit of the government, not for the benefit of you and me, not for the benefit of people who are having to use the system. Online systems are very convenient, but they shouldn't be used to exclude people, which they are. And we should really essentially just be placing more benefit on, more emphasis on the benefit of the personal touch. I mean, people respond to someone who can explain things to them properly. And I think Alba should be looking at stuff like this because having some sort of proper costing plan for this shows you what kind of country you would like an independent Scotland to be. And that's pretty much it. I mean, if anybody thinks I'm minimizing the digital divide, has different opinions, feel free to bring it up in the questions.
Thank you very much, Gordon. What I'll now do is pin all the panel members to the main screen, if you just bear with me. Okay, so we've now got all the panel members pinned to the main menu. Scott, Forbes, your visuals are off, mate, just so that you're aware of that. And I'll start with Eva. Was there anything from the other panel members that you'd heard that you wanted to come back on in any way, Eva?
Yes, please. I found everybody very interesting, but I'd particularly like to ask John if there are arrangements in hand or plans to train sheriffs and lawyers as to how to interview children along the lines that he says we should be doing. Thank you.
You're on mute, John.
No, Eva, there aren't plans to do that. This is something I've been trying to introduce and spread the word about, teach about, write about since 2010. There aren't plans to do this. In fact, what we have is in relation to developmentally appropriate questioning of child victims and witnesses, we now have a ground rules hearing in criminal trials, which you may have heard of and you may be familiar with, where the judge gets to be the gatekeeper who approves or disapproves proposed questions by counsel or by solicitors in the sheriff court. The difficulty with that is that judges, as you've asked, are not trained in relation to developmentally appropriate questioning. And look, if I just might digress, for lawyers, for all the lawyers among you, we're all taught that you ask an open question by starting with who, where, why, when, what, how, describe, tell us, explain. Yeah, that's all familiar. I'm afraid you're almost bound to fail, according to the scientists, if that's how you start off asking developmentally appropriate open questions.
Eva, you want to come back?
Aye. I'm going to have to come on a training course, I can see. Thank you.
Yep.
John, I'll stay with you as soon as you've got your mic open. Was there anything that any of the other panel members had said that you wish to either question or add to anything?
I was really interested in what everyone had to say. I must say, the material that Eva was talking about is so familiar to me. The sheer unsatisfactory nature of the way that those particular acute matters that affect parents and children are dealt with, exacerbated by the unsatisfactory arrangements in the pandemic. I was really struck by that. Scott's material I was really interested in as well, because quite a lot of what Scott was trying to highlight in some ways overlaps with what I've highlighted as being one of my principal areas of interest here. But stuff that Jimmy was talking about, and it's all concerning stuff and familiar territory.
Thanks, John. Andy, I'll come to you next. Was there anything that any of the panel members had said that you wanted to come back on or add to?
Actually, there was a few things that I was wanting to take up, so I hope you'll get a wee bit of time. Firstly, John, I recently had a case which involved an English psychologist in a Scottish residence case, and we were trying to get information from her about the views of the child. She'd done a fairly brief report, and she couldn't give evidence of the truth, but she suggested that maybe someone could speak to the child. And we said, well, a child welfare reporter could speak to the child. And she said, well, is the child welfare reporter trained in any way in interviewing children? And we said, no, they're just lawyers like us. And she couldn't believe it. Yep. She couldn't believe that the court was sending people out to take children's views in contentious residence cases, who had no training at all. And she actually thought that's potentially going to cause more damage and be completely, what's the word I'm looking for? It's going to cause, it's just not going to be helpful.
It's harmful.
Yes. So she had huge concerns about that. And today, I've had a situation where, again, very contentious contact case. And the child welfare, our position is there's significant parental alienation in one of the households. The child welfare reporter goes out to take the children's views and takes the views in that house, not at school, not at a neutral venue, in that house. And I just think, where's the value of that?
There may be none. But the point you raise, Andy, is a really important point. Child welfare reporters charged with that important task don't have special training to communicate with children in a developmentally appropriate manner, as I've been at pains to explain they should have. Children's hearing members don't have that training. Sheriffs don't have that training. A sheriff can be appointed from a commercial background, never having worked with children to any extent, not having children of their own, not that that necessarily helps, but the point I'm making is never having had any direct contact with children. And then we tell them that they don't need any special training to interview a child alone, apart from with the sheriff clerk in chambers, to ascertain their view. Now, come on, it's nonsense, and the science tells us it's nonsense. It's harmful to children.
Don, can I say something?
Aye, you come,
Don?
Scott. And you come, Scott, yep.
That was very interesting, John. The people need to be trained to speak to kids or interview children, and I totally agree. If you look at society, especially social media, children are now categorised, middle class, LGBT, there's trans children, there's this children and that children. Most children, and generally speaking, most children, they go to the children's panel, come from house in the States and Scotland.
Yep.
And to interview their kids, you need extra special training. Their children are different from most people who are interviewing them. Now, I've had personal experience a long time ago. I'm 56, but I still work in that. You know, I've done a lot of work for Children First. And I found a lot of the kids that I met, they could relate to me because I could joke with them and play with them. I knew their backgrounds and could relate to them. The people who were interviewing them, speaking to them, come from massively different backgrounds. I don't think academic training can give that gift, if you like, to interview the kids for, say, Nidri, Craig Miller, Drumchapel, wherever, you know, and you come from Bearsden. I don't think training can give you that. That's only my opinion.
Well, look, we're all different.
No, definitely.
We all come from different backgrounds.
Oh, definitely.
But the point about the way the developmental scientists have provided us with tools, methods, and strategies to be able to ask developmentally appropriate questions of children equalizes, or is devised to equalize the difficulties, so that what you're trying to do in any forensic communication with the child is to give the child, if the child wants to, the opportunity to express a view in their own words. Now, first and foremost, in order to be able to do that, they have to understand what it is they're being asked to do, and you have to test that. And there are particular methods and structures that the developmental scientists have set out that assist in doing that. Now, I'm not, in saying that, I'm not denying the validity of what you say, that if you're from a similar background to these kids and you're able to meet them on a level playing field, if you like, if you're able to talk their language, then you will have a special connection with them. That's right. But that's not necessarily determinative of how matters should be regulated in the formal context of forensic communications.
John, sorry, listen, I probably didn't communicate that properly. Listen, I got away with most things with the kids from backgrounds because I can relate to them and make jokes and I can get things to them. That's a personal thing, but on a bigger perspective.
Yep.
Only my experiences. If you take a child to a black suburb in New York, the ghettos, and you get a white middle class person going to question that child, irrespective of training, or education, or whatever, that kid will never ever respond wholeheartedly to that other person.
That might be right.
Now, so the only argument is that no, for me, I'm saying a lot of the times, only maybe I'm trying to think how you explain this properly. Is I'm not saying me. Listen, know me, please. My experience is sometimes it'd be better coming in within the community children's panels rather than a panel where three people where the kid doesn't relate to, the child doesn't have nothing in common with the person. Even when you're trained to ask questions, you know this, you're a good advocate. Listen, I know questioning. And sometimes before you even get to the person you want to question, there's a big barrier up before you never ever get to the truth. That's only, listen, that's only an observation over the years that I've made. Kids don't relate to people who don't understand their background. That's all. As I say, that's only my. Well, listen, not my opinion. I don't mean me personally, honestly. I mean generally speaking. Social workers go into kids now and speak to kids like to Castlemilk or Nidri or wherever, and then before they even have a conversation, irrespective of training and education, before they even start the communication, there's a barrier between them.
Yep.
A barrier. You know?
Yep. Well, you may be right, but what we can do and what we should be doing is using the tools that are available to try to equalize or neutralize those sorts of factors that would be at play, and to try to afford a child or a young person the opportunity to express themselves or not express themselves in their own way.
No, I get that totally. Listen, I'm not demeaning the whole system. I'm just saying that over the years, this 40 years I've been involved in it, and even still, I still see kids who will not communicate.
Yep.
No lawyers so much. No,
Yep.
And I'm not being. If there's anybody on here that's social workers, I'm not being critical. I just find that they're in a different level, and before they even go to that child, there's barriers up before they even go there. So,
Yep.
So it's very difficult to get to the truth. Or I heard a scenario there earlier when you interview a kid, and you're in the kid's home, and there's trouble between the mum and the dad, and you're trying
Yep.
to take the kid's side. You can never get the true perspective in that home.
Yep.
You can never really get the true perspective for the kid, even when you take the kid away from the home. If the right person is there to ask the question, and maybe not putting that across properly, but
No, you're putting it across perfectly well.
I just always thought with kids there should be some in them. Go back to a community, find people in the community. Do you remember, John? I'm looking at you. I hope I'm not guessing you. You're an elderly gentleman. I'm at my age, 56, 60, whatever.
Correct.
Am I right?
Correct.
Now, when I was a child, police officers were picked from like welders and bricklayers and joiners who wanted to leave their trade and become police. And still, listen, I was a wee rogue, all this to school and whatever. But we still had some sort of respect for the police officers because they had come from that background. They understood you. They maybe kicked you up the arse, but they understood you, and there was a rapport between you. I feel over the years that rapport's away. Now, it's all right, that's only one sector, police. Now when you go to like social workers and you've got a child with a real rough background, and by the way, I never come from a rough background, they just listen, I was a wild child, it's a simple way. And then I see now social workers, when they talk to kids, and most social workers are middle class, and then they go into like a housing estate, and before they even begin conversations, there's a barrier. Even when the kids start talking to the social worker, the kids sometimes playing with the social worker, and the social worker doesn't realise what's happening. So I just think there should be more community involvement when children are involved. That's all I, you know.
Thanks, Scott.
No.
John, we want to come back on anything that was said there by Scott, and we'll return back to Jimmy thereafter.
Yeah, look, what Scott said is perfectly valid. I mean, we all know that children will relate better to people whom they understand, whom they can directly relate to. There's obvious validity in that, but we know also that within the forensic structures, which is really what I'm addressing myself to, within the formal settings, within courts, within children's hearings, within these formal types of settings, you don't get to pick and choose the people who are going to communicate with you and going to ask you questions. But what we can do is give them the skills to be able to neutralize the developmental aspects and disadvantages as best can be neutralized.
Thanks, John. Jimmy, was there anything that you wanted to come back on, anything that's been said with the panel so far?
Yeah, I'm going to be picking on John too.
Okay, John, just leave your mic open, please.
I was fascinated by what you had to say, and I want to put a historical context onto it. If you remember back to the Orkney inquiry,
Yep.
Try to think how many years ago that is now.
30.
Is it? Well, that brought up a great deal about interviewing of children. And my old force, Northern Constabulary, took a lot. I think it was Lord Clyde's report, was it?
Yep.
And took a lot on board and introduced pretty extensive training for selective officers, which included a child psychologist. I think she was from Cleveland, who was a recognised expert at the time. And the training took about 6 weeks before you were given the go-ahead to interview child victims. It was mentioned at the time that what was the point of all this training being done to interview child victims when no training was in place to interview child accused. And I was quite surprised to hear that it doesn't seem to be widespread that children are being interviewed when accused, quite often of serious crimes, by a person who is trained to interview a child, which is a completely different thing from interviewing an adult, as you've detailed. So how far have you got on getting, and I'm not just talking about the police service, I'm talking about prosecution, judges. I think it's essential that they're all trained to interview children, whether witnesses or accused.
I agree, Jimmy. And I have to say, we're not talking about rocket science here. We're not talking about something that would cost a lot of money to train people who ask questions of witnesses as a matter of their professional duties, and probably have done so for years, sometimes for decades. We're talking about something that they should be very well able to acquire just a different approach to, rather than the, as I've said to you, the who, where, why, when, what, how, describe, tell us, explain scenario. The scenario that the scientific basis teaches us is to think about the effect of the questions that we're asking on the child's memory, or the person's memory, for that matter, if the person you're asking a question is not a child. And memory, they tell us, can be thought of as a continuum, starting at one end with recall memory. That's where you actively recall things, where your memory is actively engaged and you're thinking about, what do I remember from that? And you are at your own pace recalling things that you actively remember. So you've got recall at one end, and at the other end of the memory continuum, you have recognition memory. These involve two different memory processes. Recall at one end, recognition at the other. And all the way along the continuum, at different points, you can access a child's memory by asking particular types of questions. So there's a preferred hierarchical questioning strategy to help you do that. This is what I'm talking about when I talk about a disciplined approach. And the strategy is, first of all, start with open recall questions, such as, tell me what happened, tell me more about that. Cued recall next, where you use some detail that the child's given you. You mentioned your Uncle Jimmy. Tell me all about your Uncle Jimmy. Tell me when you first met your Uncle Jimmy. Can you remember it? Stuff like that, okay? So open recall, then cued recall, then focused recall, which are questions that probe for more detail, such as what, when, how, why. Those sorts of questions. Now, pause for a moment and think. The lawyers are starting off with those questions as their preferred first entry questions. They are only third in the hierarchical preference. And after those probing detail questions, they move on to recognition side of the continuum. Focused recognition. Was it black or blue? Was it this or that? You mentioned a car. Was it white or was it pink? That sort of thing. And then the last and least preferred question type is suggestive recognition. Say, you're a former police officer, say you've got oodles of evidence saying that somebody who assaulted someone else was wearing a black furry Cossack hat and a child saw it. And you know from 5 other witnesses that he was wearing this black furry Cossack hat, but the child hasn't mentioned a hat. In those sorts of circumstances, you might think it appropriate in the exercise of judgment to suggest, was the man wearing a hat? And the child suddenly might say, yeah, a big furry hat type thing. All right. So those are just examples of the preferred hierarchical questioning strategy. Open recall, cued recall, focused recognition, suggestive recognition. And the only complication to that is every time you ask a question other than an open recall question, you default back up to open recall as soon as you've tarnished the process by going for a less preferred one, so that you're always defaulting to open recall questions, and you therefore elicit the maximum amount of free narrative recall that a child can give in their own words. That's
how far have you got? How far are you down the road in having trained officers interviewing child accused?
Not far at all, because as a matter of policy, the Scottish Government have decided not to use the NSCHD protocol basis, which is the scientific basis, to train interviewers who will interview children who are in conflict with the law. They're only being used in relation to child victims and witnesses.
I find that very strange, actually.
It's very strange.
The evidence over the years, over the last 30 years,
yep.
Everything you say is absolutely. It is so easy when interviewing a child. Auto-suggestion. You can get them to say almost anything.
Correct.
So, and when you're interviewing a child victim, you have to be very careful.
And even, to follow up on one of the issues that Scott was keen to highlight, even in relation to an adolescent like Luke Mitchell, Luke Mitchell didn't make incriminating statements within the police interviews that he was subjected to, but the police officers did goad him. They goaded him into behaving badly and into swearing and into incriminating himself in that way, so that when the case went to the jury with the parts the Crown wanted to rely on, although he didn't say anything material to incriminate himself in a murder, they made him look like a horrible guy. And that added to the evidence that justified the conviction.
I can't see that as fair at all. I honestly wish you the best in getting a more open approach to the interviewing of, child accused. I think, to be quite honest, in Scotland, to the best of my knowledge, and I still keep in touch with some of my colleagues, the interviewing of child victims is of a pretty high standard, that it really needs to carry on to all children, whether they're victims or accused.
I agree.
Thank you both. Andy, I'm going to come back to you. Had you finished in your point that you were making to John?
Yes, I think I had. I think I had. Yeah.
I was just, I wasn't, I never come back to you after I'd spoke to Scott, so I was just wanting to clarify that. Finally then, Gordon, have you got anything you'd like to come back on with any of the panel members before we open up for audience questions? We've got a few hands up. Yeah, I have just kind of one general question for the lawyers. I mean, it's obvious that my digital problems are very different in tax from the ones that we've been hearing from the rest of the panel, but most of my problems are because the government quite likes it that way, because they don't think it's important, they don't really want to change. And I'd just like to hear from the lawyers, the things that they've been talking about. Is this arising because of cost savings, because people are quite happy for things to run that way, because they don't really want to change, or maybe it's just kind of incompetence? But like I said, I'd like to hear their opinions on that. Okay, so who's want to go first then?
I could chip into some of that.
On you go then, Andy. Please do.
Some of the virtual stuff that's been brought in, I think is trying to get round the fact that there are only a certain number of physical courts available. So, for instance, a court could run a number of digital courts with they've appointed a whole load of new sheriffs, so they can run a whole load of digital courts with these sheriffs not in the court building. So they can do Falkirk, for instance, they could have 2 sheriff and jury courts, they could have a summary trials court, and they could have as many civil courts as they wanted, but the sheriff wouldn't be in the building. So that's part of it. They think this is a way of clearing the backlog, and they don't care that although it may help clear the backlog, it's a pale shadow of what justice should be. So that's part of it. I think another part of it is people cannot get fair away with themselves, thinking they're blazing a new trail, the white hot heat of technology, you know, and they just completely take their eye off the ball that what they're actually doing is providing a service for citizens, as opposed to making themselves feel good that they've introduced some new tech to the system. They just don't see the effect that introducing these procedures has on the public and the accused, and I suppose the lawyers as well. They're trying to use it. So there's a number of issues there, but certainly trying to push through things faster and cheaper is certainly one of them.
Yeah.
Thanks, Andy. Anybody else want to come in on what Gordon had said there? Eva, are you unmuting?
Yeah, I was just going to add that there are a few areas of procedure in civil matters where conducting business by Zoom is okay if it's only the lawyers that have to attend the hearings. So if you've maybe got a case that's calling because you're trying to agree dates or something for your continued hearings, then that kind of thing's okay. But once you're talking about arrangements for children, then conducting that business by Zoom is really unfair, but it's most unfair on the poorest who don't have, as we said earlier, ready access to either their broadband Wi-Fi or a device that's a reliable one, because they either don't own the device or they don't have the money that they need to service the requirements. So I think actually with the Scottish Government, there's a very deliberate, plausible deniability where the surveys that they've done on the success of virtual technology for courts is primarily based on the experiences in commercial cases or cases where people are private fee-paying clients, where money's no object and resources are limitless. So I think that it's the poorest in society, as always, that are suffering the greatest. And it's lawyers like Andy and me who do a fair amount of legal aid work that could be the best folk to tell the Scottish Government where they're going wrong, but we're also the folk that they're not listening to, and they're not likely to listen to, because they like the nice tidy information they're getting from others further up the line who can talk about commercial things having been a success, and how they had a 5-day hearing with you know, a couple of dozen witnesses who were based all around the world, and everything went according to plan. I've yet to have a case based only in Clackmannanshire that's gone according to plan in that fashion. So again, I think there's a bit of a deaf ear being turned to us. Thanks.
Thanks, Eva. I'm now going to invite questions from the audience. So the first person, I'll pin you to the menu. It's going to be Jane Laidlaw, who will be the first person to ask a question. Jane's a returning panel member for our Safeguarding Scotland's Bairns at the beginning of the month. So I'm just going to add you onto the main menu, Jane, and ask away.
Thank you very much. I actually don't have a question, but rather some observations that I wanted to contribute, and really in response to what John and Scott were saying earlier. Much has been stated already about the sort of forensic questioning of children and the specialist training that's required for that to be successful and to actually not cause any more trauma to children and young people. But what I wanted to talk about really was the conditions in which those questions are asked. And I'm saying this from the perspective of having been the Childline Service Manager in Scotland when I worked with the NSPCC for almost 12 years. And over the period of time that I worked at Childline, we heard from hundreds of thousands of children and young people who spoke about and actually disclosed to us or to our counsellors horrific things that had happened to them. Now, sometimes what they had disclosed then went on to be heard in court and have successful convictions. But what I really wanted to speak about was what children told us about being involved in the process and why they then came to Childline to speak. And often they told us they were coming to Childline because no one else would believe them. Some of them said it was the first time they had ever told anyone, and they were choosing to come to a service that had nothing to do with the process. So they needed to find a safe space where they would not feel judged, a space that was child-centred, where the questioning, well, traditionally Childline, it's been going for about 35 years now, but it came from a sort of Rogerian model of counselling and has then developed into other things, but essentially provided a child protection service. And in that sort of, when children came and spoke to us and were having the counselling, they set the pace. They disclosed to us when they were ready. It wasn't about counsellors having an agenda to meet, a conclusion to reach, evidence to be gathered, statements to be written. It was about what the child wanted to share. So sometimes that questioning or that counselling process, rather, that relationship was built up over a period of weeks and months that I don't think is available in the system the way it is just now. Sometimes that's expected to take place over a couple of hours or a couple of hours over a few days. And that isn't child-centred at all. Another thing that was really important is that children wanted to have ownership over any agreed actions. So when we got to a point in the process, maybe after hours, maybe after weeks, when we were deciding what to do next in terms of making an informed disclosure to, say, social services or the police, that children had a say in that. And it's going back to what was said earlier by one of the speakers about the articles of the UN Convention for the Rights of the Child, about having their views and opinions taken into account. And that was really critical for hundreds of children that we spoke to. You know, we always sort of advocated for independent advocacy. And again, it's about speaking to, someone had commented earlier about being interviewed, say, in front of the parents who were the perpetrators of the thing that was being alleged. And of course, a child is not going to open up in those circumstances, or they may say what they think is the right thing to say in front of the parent they want to please at the time, and then retract it at a later date because it's not what they feel is the truthful answer. So going back to the sort of those are the kind of general conditions that help young people open up and be heard and fundamentally be believed. And if they think they're being questioned in a way that feels like an interrogation, or that they're being judged, and this is part of, again, what I think Scott was touching on about speaking to someone where you relate to the person, because if you can relate to the person, you feel that you're less likely to be judged. And John was speaking about the who, what, where, why, and when, in terms of, you know, how we question. But I think what I want to say that was missing for me is children need to be empowered with information. They are often left out of the who, why, where, what, and when. Nobody tells them the process. We need to find a way of engaging that's age and stage appropriate, and a language that they can understand and feel empowered by what happens next, who's going to be told what I've said, when I go to court. What, you know, I think there's things that have been put in place around courts, but there's other parts of the process that children are often excluded from, or, you know, it's not shared with them. It's all very adult, and we need to empower them with that knowledge and information. And that was something that came up time and time again at Childline. So that's all I want to say. Thanks very much.
Thank you, Jane. Would anybody like to come back on any of the... When you go, John, please feel free.
Thanks, Jane. That's obviously material that you know well, and reflecting on your great experience and really important experience and all of that. The answer that other countries have come up with and that we are trying to formulate just now an approach to is the Barnahus model, at least in relation to child victims and witnesses. And a properly constructed Barnahus model should be based on evidence, because behavioural scientists and developmental scientists and all sorts of experts have been involved in the whole idea and development of the ethos of the Barnahus model over the last 30 years. Originally, you know, beginning in Iceland and Norway and Sweden, and in Finland, they have a particularly robust model as well. We're embarking on it now. And it's really important that in Scotland we don't get sidetracked by trying to add our own whistles and bells, if you like. It's really important to stick to the evidence of what works, what's trauma-informed. How do we know it's trauma-informed? Where's the research? Show me the data that proves that that's how. Show me the data that proves that you will not alienate 14, 15 and 16-year-old young women if you call it a Bairnshuis, for example. Show me the data. It hasn't been done, but it has to be evidence-based. So if we get these things right, it could be a really fantastic facility along the lines that you are suggesting is required, and of course it's required. If we want to look for a model that already operates satisfactorily in those regards and in those respects, we can look at the Lighthouse in London. And I don't know if you're familiar with that facility, but you can Google that. Yeah. The Lighthouse in London is, you know, I have ongoing collaboration with them. Fantastic facility. Kids there can actually give their evidence by remote link to courts from the Lighthouse that they know because they built up a relationship with the people there, and it's staffed by a whole different team of people with, you know, the sorts of forensic skills that are required. Forensic and therapeutic, I should say.
Yes, I think the therapeutic thing for me, John, is incredibly important, because following for the NSPCC, I was then head of the National Confidential Forum that heard testimony from adult survivors of horrific childhood experiences in the care system. And I suppose I just want to pick on about the training, about why being a trauma-informed, therapeutic, active listener or questioner, whatever, is so critical. And it was something, you know, that Scott was saying earlier. I managed a team of clinicians and a procurator fiscal who were all very experienced listeners and very good at asking questions in a very empathic way. And one of those, Professor Kate Davidson, I don't know if you're aware of her, John, she's attached to one of the Edinburgh universities. And I can only describe Kate as frightfully posh, because I would much more relate to Scott, for example, and be able to relate to children from the schemes and have that sort of dialogue on a level with people. But I can say that when I saw Kate in action as the professor, and absolutely an academic, and she has no children, so I just want to say that as well. She was an absolutely beautiful counsellor and really empathic, and had a lovely manner about her that people said over and over they could have spoken to her for hours, and it was about the conditions that she created, where people who came in to speak to us felt that they were believed and that she was completely non-judgmental. So I don't think it's the case that, you have to be able to speak to people on that kind of same level. Yes, I think that makes you relatable, but it's not essential. I think what's essential is just, being a good person with the right training, and doing a good job. And as you say, having the skills, the knowledge, that expertise, and applying it really well.
Thanks, Jane. Anybody Johnny, you want to come back on anything that Jane's said there?
Jane, 100%, absolutely correct. There's a lot said these days about trauma-informed this and trauma-informed that. In that sense, it's a sort of flavour of the month type thing. In order, as I understand it, in order to be trauma-informed, any practice has to be able to demonstrate that it is trauma-informed. And that's normally done by producing data and showing statistically that one thing works and one thing doesn't work. The scientific basis that I'm talking about in relation to forensic communications with children, just by way of explanation, it is unique in that it's compiled from data gathered in real cases, and not just 10 cases, but because it's from the States and because they have the opportunity to have available to them huge data sets, 50,000 cases, So it's trauma-informed because the kids that participated in the cases that they analysed were kids who really had been involved in trauma. So the behavioural scientists were able to factor all of that into the sort of approaches. And, for present purposes tonight, I haven't been able to go into all of the basis of the approaches, but you will have heard of the need to establish rapport, for example. Yeah. So rapport in the context of a forensic interview with a child, for example, is not just about striking up I'm John, what's your name? Okay, Billy, do you like the football? It's not, it is partly that, but it's not just that. It's forensically relevant. It's also referred to in the material as social support. It's something that when things become difficult later on in the interview, you can fall back on. You have that basis of understanding for your communications that you can fall back on. So, there are many, many aspects to this. I recognize all of what you're saying, and it's absolutely valid and fantastic experience. The scientists can tell us about it all. Other people have done it elsewhere, and we should be looking at them and looking at their evidence base rather than coming up with some quirky sort of Scottish, this is the Brunshouse model. You know what I mean?
Thanks, John. We're going to invite Denise in to speak now. Just going to bring Denise onto the main menu. And Denise, just whenever you're ready.
Hiya. I've got a couple of points to make. The first one goes back to Eva's discussion about the inequalities between care-assisted people and co-parenting families during COVID. I'm wondering if there's anything been implemented to help and support mothers or parents and their children going through the visitation rights order or the lack of visitation throughout COVID, and what kind of impact that's going to have on the parental alienation and maybe even resulting in mothers not receiving care of their children again. Other point, if I could make it before you come in, Eva, is I think it's to all of everybody, is and what's everybody's opinions on the violence reduction units, the system of multi-agency support and within communities. I'm just been newly presented with this in one of the sub areas in South Ayrshire. I'm just looking for some opinions on it, if that's okay. That's all I had to say. Thanks.
Thanks, Denise. Eva, I'll let you address the first part before opening it up.
In relation to the first part, I am not aware of any special support being given to families, parents or children who suffered as the result of a lack of contact during the initial lockdown. In fact, I would say that you're right when you're talking about parental alienation, because I've either seen or heard of quite a few cases where there have been very serious difficulties in trying, in effect, to reintegrate parents and children where there've been substantial periods of time when they've not seen each other at all, or only been able to communicate by way of FaceTime or emails. I think there's been issues probably throughout the whole country in the last few months, if not year or so, whereby children's panels that had to make decisions about children were getting patchy information, and generally were not seeing the children about whom they were making the decisions, were not able to see whether there was interaction between the parents and the children at all, because they weren't all on the screen at the same time. And I don't think I've been at a panel actually in the last 2 years when the children have been present. So there's a massive problem there, which I think is not being addressed. If Andy knows differently, I'm sure he'll say, but I think that the pendulum has actually swung the other way, and a lot of families will remain separated from each other, primarily because things and systems and processes went so horrifically wrong in the last year, year and a half, 2 years.
Thanks, Eva. And John, you've got your mic open, so is there anything that you wanted to come back on what Denise had asked for the second point, the violence reduction unit?
To be honest, it's not something that I've been involved in. It's obviously important material. It's obviously the crucial backdrop to the really acute problems that need to be dealt with that Eva's just been addressing as well. It's look, we need to offer people realistic solutions in order that relationships aren't completely destroyed between parents and children. Why? Because it's harmful to children.
Thanks, John. Andy?
Denise, there's nothing we've put in place to try and undo the damage that's been caused over the last 2 years, and for some families that will never be made up. It's 2 lost years. It's 2 lost years where they haven't seen each other. It's 2 lost years where they have had no effective redress, either in front of the panel or in front of the courts, and nothing will be done about that, I'm afraid. It's just lost time for them. As far as the violence reduction unit goes, we don't have that in our area. I didn't actually know it was being rolled out into South Ayrshire. I thought it was just only in Glasgow. I know that it seems to have had some success there. The only contact I've had with it was they were at a course I was at and they did a talk. And I have to say, they did a talk to a room full of criminal defence lawyers, and we're all a bit cynical about it, but it appears to have made some difference. My one thought about it when they were talking about it at that time, they were aiming it at 14, 15, 16-year-olds. And my thought was, that's too late. if you're a 14, 15 and 16-year-old young man, because let's face it, they're usually men, you've left it a bit late to become involved and try and divert these guys away from violence. It may be they've moved the ages back a bit, but I suppose it's a resource issue. They have to target it where the need is greatest.
Thanks, Andy. Does anybody else want to have a comment on Denise's points that were raised? No. Denise, was there anything that you wanted to come back on anything either Eva or John or Andy had said?
No, it's just quite sad that there's no support left or put in place for these families. It's been sadly left behind. I know a few of them myself, children from babies, and they haven't seen parents for 2 years, not even online, because of the digital poverty situation as well, which has then resulted in the same cycle of behaviour then happening again. So you can't see a result at the end, and I just think it's really sad, and I'm wondering if there is anything that we can maybe do to try and change things, but that's maybe looking too far.
Well, thanks very much, Denise. I mean, the full purpose of having events like this and the Alba Party trying to organise events like this is in hope to pinpoint some of the failings that we are identifying. It doesn't make any difference for the people that are going through it at the minute, unfortunately, but hopefully if it prevents any other families from going through similar instances, then this is what events like these are being scheduled for. Thanks very much for your comment, Denise. I'm going to invite Janet to speak in a wee minute. I'll just pin you to the menu first, Janet. Hey, Janet, on you go, whenever you're ready.
I'm actually still reeling at I think it was Andy who mentioned about the 14-year-old boy who had been strip searched without an appropriate adult. Is that something that's allowed? To me, that's abuse, if no sexual abuse. Am I wrong there?
Andy, I think it may have been Scott that mentioned that. I could be wrong in that. I think Scott mentioned something to do with that. But Andy,
yeah,
you get your make open.
Jeanette, the guy I was talking about wasn't a child. He was vulnerable because of mental health difficulties, but he was an adult. Doesn't make it any better, but he was an adult.
Oh, I thought somebody had said about a 14-year-old boy who had been.
May well have been Scott that said that about a 14-year-old boy.
Yes, it was.
Was that a strip search, Scott, or was that a combination of your 14-year-old and then Andy's comment about the strip search that had been taking place with a vulnerable adult?
Oh, when Luke Mitchell was first taken to a police cell, he was 14 years of age, and he got what the detective superintendent called the full works. They stripped him naked, they took hair samples, scrapings for under his nails, photographed him naked, and then interrogated him. And I use the word interrogate purposely because the appeal court and the high court accepted how a 14-year-old boy was treated.
It's again the justice system that we're operating under. Like everything, there'll be things that go on that shouldn't. Is the best way that we can kind of try and compensate that.
Oh.
I just feel, I mean, I've got a 14-year-old grandson who's, I mean, he is a child, to be quite honest with you, and if the devastation that would cause somebody even at my age, you know.
And there's been a high profile thing in the press over the past couple of weeks about I think it may have been a 15-year-old girl that was strip searched in school while she was on her menstruation cycle by police. I mean, that's been well documented in the press over the past certainly week and a bit that I've noticed. Eva, I'm going to ask, there's Jimmy raising his hand. Jimmy, you want to come back in on something? You go, Jimmy.
Unless things have changed very recently, during a strip search, you're not allowed to leave anyone naked. you know. It just shouldn't happen. So whoever's strip searching people and leaving them standing naked is breaking procedure.
Listen, the utmost respect, procedure is something that's very seldom adhered to.
Well, it should be adhered to.
No, I understand that. Listen, I understand that. I'm not having a dig. Like, come on. Listen, listen.
Well, a lady there, I think Jeanette said that's abuse. It is abuse.
Yes, listen.
It's abuse. There's methods of strip searching people, as you put it. You don't at any time need to leave them naked.
Listen, listen, the boy wasn't strip searched. The boy was stripped. His clothes was taken off from me. He was friendly examined. And then, so it wasn't a strip search. The girl in London, the black girl in London, was strip searched by police officers. The boy Aspic, his 14-year-old, was stripped naked, clothes taken off him, and friendly examined. The underneath his nails, his hair samples, photographs naked was taken from without an appropriate adult.
Well, you can't defend that. It's as simple. You just can't defend that.
You can't defend that.
No, you can't defend that.
It was accepted in court. This is a big thing. The courts accepted the way he was treated.
Well, why should the court accept something like that?
I don't know.
It's a wee while now, but I've seen the actual procedures for strip searches. And sometimes strip searches have to be carried out. It's as simple as that. But at no time are you allowed to leave the person naked. It's as simple as that. So whoever's doing these strip searches obviously don't know the instructions they're under. And they shouldn't, a court shouldn't accept, as you say, a 14-year-old boy being left standing there completely naked. You can't justify that at all.
Thanks,
Jimmy.
Jimmy.
Can I ask you where you are? No, go. Sorry.
You're all right, Scott. Was there something you were going to say?
No. I was going to ask John where he worked in Glasgow, but no. Cool.
Right. Well, just past 9 o'clock. So I'd just like to thank each member of the panel for taking the time this evening and contributing to what's been a very interesting topic of conversation in Unjust Scotland. I'd also like to thank Eva Comrie for organising this evening's events. It's been a pleasure not to be referred to as the accused or hear the word locust mentioned even on one occasion tonight. I was just maybe going through my own previous experiences, etc. Pretty much similar to Scott's by the sound of it. But I would like to thank each member of the panel for their contributions, their comments, the audience for sitting and listening intently, and also for contributing as well. Thanks very much from TweetStreet Scotland Occupied, from Alba Party and from the Alba Equalities team. It's good night and hope to see you again soon.